Hello learners, we've been discussing about the role of applicable law for integrating environmental provisions in investment dispute. Now in this video we'll be looking at to what extent the past decided cases have considered environmental law, integrating an international environmental agreement. So we'll discuss very few examples here. The very first example that I would like to talk about is S.T. Myers versus Canada. So this case involved the transportation of hazardous waste from Canada to the United States. So there are two international agreements that are directly relevant to this case, Basel Convention and Transboundary Agreement. We could also see Article 104 of NAFTA list out certain environmental agreements which would prevail over the NAFTA provision in case of a conflict, and Basel Convention is mentioned there. Even the annex to Article 104 that also mentions transboundary. So that is clearly, the applicability of these instruments was not had to be brought into the framework of investment dispute by the arbitral tribunal. It was already explicitly mentioned in NAFTA itself, right. So there was not much of a scope of discretion for the arbitral tribunal to not to consider these agreements, but the fact was only Canada had ratified Basel Convention, United States did. So there were again some complexities with regard to what extent the provisions are applicable. But what here I want to highlight is the tribunal had referred to these agreements, right, and then moreover you also have North American agreement for environmental cooperation, side agreement of NAFTA, which had reaffirmed the Stockholm Declaration and Rio Declaration. So all of these environmental agreement was there, and that was looked at by S.T. Myers tribunal. But after looking at these environmental agreements, S.T. Myers relied on WTO Article 20 jurisprudence and came to the conclusion that the state has a latitude to take any measure to choose the level of environmental protection, but that has to be a least restrictive approach. This is something that is borrowed from WTO jurisprudence. WTO, while interpreting Article 20, appellate body always take this approach that the measure should be a least trade restrictive approach, and that is what the S.T. Myers tribunal also had come to that particular conclusion. So, but at least we have to appreciate the fact the S.T. Myers tribunal did consider the applicability of in environmental agreements. It is a different question. Not many scholars have agreed with the fact that the measure has to be a least restrictive approach, because how do you then sort of justify the mutual reliability of environmental agreements and that of an economic agreements. So this should be supplementary to each other, not that one should be put at a higher pedestal. So that is not something that ideally should be done. But we do appreciate that S.T. Myers tribunal had considered international environmental instruments. Okay, so moving on to the next case, Marion Ungeleb and David Ungeleb case. So in this case, again we know we've discussed the case in detail before. So we know that Costa Rica had taken measures in order to protect the nesting of endangered leatherback turtles, and Costa Rica did refer to Inter-American Convention for Protection and Conservation of Turtles, so and also relied on its own constitution. But did the tribunal give any reference to this convention, or did the tribunal use it for its analysis? No. The tribunal only stated that Costa Rica has violated its own laws and then stated that it didn't pay compensation, so that amounts to expropriation, and then awarded compensation. So here we could see that an international environmental agreement was not relied on by the tribunal. At least a reference could have been done, because the regulatory measure was again taken for an endangered species, leatherback turtles, right. So that is the second case that I wanted to look at. The third case is Allard versus Barbados. We had already seen the Canadian investor was the only one who had who had made an allegation against the host state, saying that the host state did not take any environmental measure, right. So this is the, usually it's always that the investor challenged the environmental measures, but here in this case the investor had questioned why the host state did not take an environmental measure, because he had invested in ecotourism. And here again the claimant relied on Ramsar Convention, Convention on Biodiversity. So, UNCBD and Ramsar Convention, and the claimant's argument was these since Barbados had assumed certain obligations under these environmental agreements, it was a legitimate expectation of the claimant that the state would implement the provisions of these agreements, and therefore, by not doing so, that the state had violated the FET clause of Canada-Barbados BIT. So, that was a contention. So, the claimant is pleading based on international environmental agreements, and also for FPS standard, the claimant again relied on these two instruments and stated that as per FPS standard, the claimant has the host state has an obligation of due diligence, or diligently protect the investment, and since Barbados had signed these two international instruments, it had heightened the level of diligence on the part of Barbados to ensure the investment towards the investment of ALAT, right. So, then the tribunal again rejected with regard to the contention of FPS by saying that the FPS stated does not impose any specific obligation on the part of host state to do something that the investor asks of it, and with regard to the FET contention also, the tribunal stated that it does not have the jurisdiction to look at the breaches of an international environmental agreement. The claimant also was not asking the tribunal to find a breach of an international environmental agreement, but rather was asking the tribunal about the legitimate expectation of the claimant that the provisions of those agreements would be implemented. So, the obligations assumed by Barbados under these instruments would be implemented. So, that is how the claimant is asking for a violation of FET clause, but since the tribunal stated that it will it does not have jurisdiction over these international environmental instrument, it stated that it need not decide whether that had given rise to a legitimate expectation on the part of the investor. Now, anyway, on the facts of the case, he lost the case because he could not attribute the environmental degradation to the state. So, that is a different matter. But this is how the international environmental agreements were relied on in this particular case, Allard versus Barbados, right. So, that was with regard to that case. Now, what are the way forward? How do we ensure that the tribunals do apply the provisions of international environmental agreements while deciding investment disputes, especially the ones that challenge the environmental measures of the host state. So, one way is to sort of may have an environmental provision in the IAA itself, as we have already discussed. Since the protection to environment, the standards for environmental protection may vary from time to time, and it is something evolutionary in nature. As we have already seen in Chemutra, lindane was not considered to be toxic, but then later it was considered to be hazardous. PCB waste in ST Myers was initially not considered to be toxic, but then it was later proved to be harmful for the environment because it takes a longer time for biodegradation. So, all of these there might be new scientific evidence. So, in that case it is better to refer any of the international environmental agreements, so that way the evolving standards could also be captured. I can give you this example of Energy Charter Treaty. On top of my head, that is the instrument that comes to my mind. Because Energy Charter Treaty has, if you see the Energy Charter Treaty, that has a reference to UNFCCC, United Nations Framework Convention on Climate Change, and also the Air Pollution Convention, and also it uses the phrase and other environmental agreements as well. So, such sort of a provision in an investment agreement, international investment agreement, will force the arbitral tribunal to integrate environmental protection provisions while deciding an investment dispute as well. So, this is one way to go about it. Maybe if the subsequent treaties or the newer generation of treaties could sort of incorporate these reference to an international environmental agreement like NAFTA had done or ECT had done, right. So, in that case the arbitral tribunal will be forced to consider or examine the issue in the light of the provisions of these international environmental agreements. So, this is one way in which we could reconcile environmental concerns and investors' concern and investment dispute, and through that way is through applicable law and how the applicable law is defined in an international investment agreement. So, in the next video we will be looking at another concept of how to integrate environmental concerns and investor concerns. Thank you.